Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law, so please subscribe to our channel. We deal with a lot of mediation in both divorce cases and custody cases. It's something that the courts usually order people into. The scenario will be your case is coming up, it's getting old, the parties haven't settled it, the court will order the parties to pick a mediator, and if you can't, the court will pick one, and you're to go before that mediator and try to resolve your dispute. Now, why does the court order that? Well, there's a lot of reasons why. The main reason is the court is probably not interested in making decisions about your family life. The court ultimately figures, with the help of a mediator, you're in better position to decide what works for you. If you can't, the court will make the decision, but the court may very well work out, for example, a parenting time schedule that makes no sense in light of your changing shifts at work, for example, and all that. So in these scenarios, it's often better for you to have a strong hand in the resolution of the case, and that's what mediators are all about. The mediator will separate the parties in general, speak to one side, speak to the other side, not exercise advocacy necessarily. The mediator is not an advocate. His basic job is to evaluate the different positions and see, is there a common ground? Sometimes, for example, two people are insisting on a particular piece of property. Let's say we have a very a highly collectible work of art. One person may be insisting on it because it has a value of $50,000. The other one might be insisting on it because it has a value, and it has sentimental value because it was given to his father by his grandfather, and then from him getting it from his father, so it's a great sentimental attachment. In that situation, you might be able to bargain it away, maybe increase the value a little bit to take care of the sentimentality. In other words, there are technical little things that you have to have a fine feel for. Sometimes the court, in dividing things up, you take this, you take that, doesn't have that sensitivity. So it's very important to participate in a mediation process where you can tell the mediator, look, the reason why I prefer this over that is because it's a family heirloom. So I'll give up more of that in order to get this. You need to be aware of that. And then the mediator, with that knowledge, can go and try to make you a deal to get you what you need. That's how that process works. It's very important to play an important role in that process as you try to resolve your divorce or your custody case. If you have any questions, reach out, and we'll be glad to help you out.